Jerusalem, ikayalami.
Ladies and gentlemen, this is LIANELLY Dear Corolla Daniels, popularly known as Dear Cor Spectre, and this is another episode of Dear Cor Talks Law. On today's episode, we are going to be talking about company law, and basically we are going to be talking about the alteration of articles. I have already recorded a video on the alteration of articles, and if you have not watched that video, then there is no point continuing this video, because this video is a continuation of the last video. And in the last video, I expressly said that alteration of article would be divided into 4 parts. The part A that discusses the alteration of article according to the Statutory Guidelines and the Judicial Guidelines, but only making reference to one case, that's the case of Allen versus Gold Reef, West Africa. This particular video, where I'll be talking about 3 cases, and then we have another video which is going to be the subjective test. This particular video, I'll be talking about the objective test. Allen's case is also the objective test. And then the last video, which is going to be the Gaboto's case and then the Sitco's case. So if you have not subscribed to my channel, I actually don't know what you are waiting for. I don't know what else you want. Make sure you go and subscribe to my channel. In fact, do it right now. Just click the button, click it. Click the button. I really don't know what you're doing. But then let's go straight. I already explained to you the whole statutory guidelines. I told you everything that you need to know about the comma in relation to alterations of article, and there is even another video where I explained further in relation to alteration of article and also alteration of memo. But this one, we are going to be talking about alteration of article, and basically we are going to be talking about alteration of article for the benefit of the company objective test. That means seeing the company as an independent entity. Do you understand? Alteration of article for the benefit of the company test, objective test. And so the first case that we're going to be talking about today will be the case of Brown versus British Abrasive Wheel Company. Brown versus British Abrasive Wheel Company. The case of Brown versus British Abrasive Wheel Company. British Abrasive Wheel Company needed to raise further capital. The 98% majority were willing to provide this capital if they could buy up the 2% minority. Having failed to effect this buying agreement, the 98% majority proposed to change the article of association to give them the power to purchase the shares of the minority. The proposed article provided for the compulsory purchase of the minority share on certain terms. However, the majority were prepared to insert a provision regarding price which stated that the minority would get a price which the court thought was fair. The court held, per Ashbury J., that the alteration was not made for the benefit of the company as a whole and could not in fact be valid. One reason for this was that there was no direct link between the provision of extra capital and the alteration of article. Although the whole scheme had been to provide capital after removing the dissenting shareholders, it would in fact have been possible to remove the shareholders and then still refuse to provide the capital. So I already told you that when we are discussing cases in relation to alteration of article, there are some things that we are supposed to take cognizance of. The first thing, like when we are looking at the fact of each case. Now, the first thing we are supposed to take cognizance of is what was stated in the company's article before the alteration. That means before the article of association was altered, what was stated in the company's article. Now, we now look at what did they alter the company article to be. What was stated in the company's article previously? What did they alter the company's article to be? And then we're also going to look at what did the court hold, and then we'll look at what is the reason for the court? What is the reason for the court's decision? What was stated in the company's article? What did the company do? What did the court hold? What is the reason for the court's decision? So in the case of Brown versus British Abrasive, in the company's article, it was not stated anywhere there that the company would have the right to expropriate the shares of the members. It was not stated anywhere in the articles. But then, the company was striving financially, and then they needed money, they needed capital, or else they would go into liquidation. And now, the majority of the shareholders in the company formed 98% of the company. Majority of shareholders in the company form 98%, which means minority shareholders would be 2%. Do you understand that? And then the company needed capital. So the company, as the majority shareholder, wanted to get or expropriate from the minority their 2% shares. And they could not do it by agreement. Do you understand? They could not reach an agreement as to the expropriation of the 2% minority shares. So they decided to, alter the company's articles to that effect. So here, it was not stated that there should be alteration. Now, here, the 98% majority expropriated minority shares. And then when they got to the court, and then their argument before the court was that the reason for the expropriation is because the majority shareholders, want to give the company more capital for the company's business. Do you understand? So they wanted to, for the majority to, give the company more capital, they wanted the 2% shares of the minority in return. Do you understand that? Now, when they got to court, that was their argument. And then the court held that this is not for the benefit of the company. The court held the alteration invalid and held that it was not for the benefit of the company. And what is the reason why the court said it wasn't for the benefit of the company? The court looked at the alteration. The alteration there was for majority to expropriate minority shares. The alteration had no link with raising capital. What the alteration was doing was expropriating minority shares, and it had no link with the company's capital. And so the court had to look at the fact that since there is no link between majority expropriating minority shares, then you cannot say that the alteration was for the benefit of the company. The alteration was definitely for the benefit of the shareholders alone. That is the majority shareholders. There is a difference. That's why in this particular case, it is called benefit of the company objective test. So when you are looking at the company, you are looking at the company objectively. You are looking at the company as a whole, as an independent entity. Do you understand? As different from the minority, as different from the majority, as different from the directors themselves. So when you see the company and then you see that, they are what the alteration seeks to do is to expropriate minority for the advantage of the majority, not to expropriate minority for the company. Now, it is my submission that assuming in the alteration they had said that they were going to expropriate so that the company can have capital, maybe the court would have looked at it otherwise. All they did was expropriate the shares. They never even stated in the alteration, because the company also reasoned that the expropriation of those shares does not in any way guarantee that the majority will still give capital, because it was not written anywhere that they were going to give capital for the expropriation of shares. So if it wasn't written, and therefore you cannot hold them by something like that, because it's going to be difficult to prove it or something like that, then if it had been included in the alteration, maybe the court would have had a different perspective to it. But since it was not included, and all that was altered was for the expropriation of shares, the court held that it was an invalid alteration because It was an invalid alteration because it was not made for the benefit of the company as a whole using the objective test. And also, so the other party were arguing that according to section 13, by the other party I mean the company argued that according to section 13, which is the same as or in pari material with what we have in section 48, they argued that the proposed alteration, if it had not been objected to at the beginning, if this proposed alteration had not been objected to at the beginning, then it is a valid alteration. Note that it wouldn't have been objected to in the beginning because they had 98% of majority shareholders. Definitely it would not have been objected to in the beginning. But then the court said that that is not the valid interpretation of that law. The valid interpretation is, it would, if the alteration is valid, then it will carry the validity of law as if it had been stated at the beginning. That means at the inception of that particular article. Do you understand? So don't get it mixed up. They wanted to play smart and the lawyering tricks into interpreting that particular section. That is section 13 of the Companies Act, which is the pari material with section 48 of the CAMA. But the court there interpreted it to be that if it is validly made, then it will carry the force of law as if it was stated as if the alteration was stated in the article from the beginning. So I hope you understand from here. Here, there was nothing stated in the article that the 98% majority can expropriate the shares of the minority. Here, they expropriated the shares. The court held that it was invalid because it was not made for the benefit of the company in objective test, looking at the company as an independent entity. So now let us go to the next case, which is the case of SIDEBOTTOM versus Kershaw. SIDEBOTTOM versus Kershaw. SIDEBOTTOM versus Kershaw, Lease and Co. Limited. The company's article of association was changed to allow for the compulsory purchase of shares of any shareholder who was competing with the company. One shareholder was competing with the company and challenged the alteration. He argued that a previous case, that is the case of Brown versus British Abrasive Wheel Company, where a change for compulsory purchase was held invalid, has not been bona fide for the benefit of the company as a whole, should be applied here too. The Court of Appeal held that the alteration was clearly valid and very much for the benefit of the company. So according to the case of SIDEBOTTOM versus Kershaw, we have to start from this now. What was stated in the company's article. Now we have to get a little bit of the facts. Here, the company, a member, okay, let me try to illustrate this. You know that in every company, you have majority, then you have minority, and then majority people, minority people. Now imagine, let us use Dangote as an example. Imagine that Dangote is done with his refinery, and definitely you are going to have a company, and then the company is going to comprise of majority and minority. And then one of the majority, or either majority or minority, but let us say majority because of convenience. Now, one of the majority is also selling fuel, or is also into refinery and all that. Now, that is what it means to compete with a company's business. When you are competing with a company's business, it means you are doing the same thing that the company is doing. So in this case, there was no part of the article that says that they can expropriate. No part of the article that says that they can expropriate shares relating to anybody, especially people competing with companies' business. Now, they altered their article to expropriate shares of people that are competing with the company's business. That means they are doing things that the company is doing. Do you understand? They are doing things that the company is doing. Now, they altered to expropriate. They order to expropriate for competing with company's business. Competing with company's business. Now, the court held in this case. So the argument that was placed before the court was that, if we look at the case of Brown versus British Abrasive, the court held that the expropriation of shares cannot be said to be for the benefit of the company. It is for the benefit of the majority. Do you understand? So when they were arguing before the court, they placed this argument before the court and used the case of Brown versus British Abrasive as a precedent. Do you understand? So the court had to distinguish between Brown and British Abrasive and the fact that is before the court today. And then the court held that the alteration was valid. The court held that the alteration was valid. And why did the court hold that? The court looked at the fact and said anyone who competes with the company's business is definitely injuring the company. If you understand what I'm saying, the act is to the detriment of the company and not to the benefit of the company. And therefore, if there is an alteration to expropriate the shares of such persons, then that is going to be for the advantage of the company, and therefore is going to be for the benefit of the company. Do you understand what I'm saying? So here, the reason is because expropriation of people competing with company's business is for the benefit of the company. Expropriation of people competing with company's business is for the benefit of the company. And then the court also had to look at the fact that there was no malice intended here. There was no fraud intended here. In the absence of malice, in the absence of fraud, then the alteration will be valid if the court holds that that thing is for the benefit of the company as a whole. So a little bit of rundown. There was no part of the company's article that stated that the company can expropriate shares. Here, the companies expropriated the shares of those that were competing with the company's business. They wanted to give it, they gave the directors the power to give it to their nominees. But that is not what we're talking about. What the most important thing here is that they expropriated those that were competing with the company's business. And here, the court held that that expropriation was valid because if you are competing with the company's business, then whatever you are going to be doing is going to be to the detriment and it will be prejudicial to the company. And therefore, the alteration has to be valid. Do you understand? So let us go to the last case when we are talking about alteration of articles. Alteration of articles, objective test. That's the benefit of the company and seeing the company as an individual entity. Let us go to the last case. According to the case of Dafen Tinplate Company Limited versus LIANELLY Steel Company Limited. Dafen Tinplate Company Limited was a shareholder in LIANELLY Steel Company. LIANELLY realized that Dafen was buying steel from an alternative source of supply. LIANELLY responded by altering its article through a special resolution to include a power to compulsorily purchase the shares of any member requested to transfer them. Dafen Tinplate argued that the alteration was invalid. The court held that the alteration was too wide to be valid. The altered article would confer too much power on the majority. It went much further than necessary for the protection of the company. According to the case of Dafen Tinplate Company versus LIANELLY Steel Company, that name is very, very hard to pronounce, but you get the gist. Dafen Tinplate Company versus LIANELLY Steel Company. Thank you very much. Now, according to the fact of the case, now, Company A was into manufacturing, steel bars and all that, steel basically, and then Company B was buying or was supposed to buy the steel bars from A. Do you understand? Because Company B is a principal shareholder in Company A's firm. Do you understand? You have Company A who manufactures the whole thing. Company B is a principal shareholder in Company A firm. And then on normal day, it's not like it is written in writing anywhere that you are supposed to buy those steels from them, but they began to buy steels from other people. Do you understand? Now, it wasn't stated in the company's article that they can expropriate, but then the company now altered their article to expropriate shares, but then they gave the majority the power to expropriate any shares at their will. Do you understand? So here, there was a problem. The problem that Alteration was trying to solve in the face of the company or in the face of the majority was that you are not supposed to be buying shares from other people outside. Sorry, you are not supposed to be buying steel from other people outside. That was the problem that the Alteration was trying to solve. But then the company, the Alteration now give the majority so much power that you can alter they altered the article rather to give to any. They altered. Okay, so basically, let me just illustrate it. So the word here is there was nothing in the company's article that says that you can expropriate shares. Here, they decided to give the majority shareholders the power to expropriate as they deem fit. So yeah, you don't need to keep altering the article anytime you want to expropriate. Just give the majority, they alter the article to give the majority the power to expropriate at any point. So any shares that comes up and they say that this person probably, they don't even need to give a justifiable reason for why they want to expropriate. As it is at the will of the majority. The court held that this cannot be said to be for the benefit of the company. It can't be held to be for the benefit of the company because there is no relationship with how a majority can expropriate share at any time, and you are saying that's for the benefit of the company. And what is the reason for that? When you have shareholders, the company is comprised of majority and minority shareholders. Even though majority have their way, minority should have their say. And so you cannot give all the powers to majority to be able to expropriate the shares of the minority at their will. At their will means that even the minority did not compete with the company's business. Do you understand? They need not do anything against the company. So far the majority is comfortable, and then by special resolution you can alter the article to expropriate the company shares at any point, then that cannot be said to be for the advantage of the company. I need you to get a progression here. The first time there was an expropriation, it was in Brown versus British Abrasive, where 98% decided to expropriate the shares of 2%. The court held that expropriation is invalid. However, in the case of SIDEBOTTOM versus Kershaw, the court held that expropriation will be valid where the other party is competing with the company's business. Do you understand? While in the third case, the court held that the expropriation will be invalid because you are giving the majority too much power. So for there, the conclusion here, the submission at this point of the objective test is that for there to be expropriation at all, do you understand? Then the other party must have done something wrong or must have done something to the detriment of the company before you can expropriate the company's the other party's shares, that's the minority shares. In Brown's case, the other party did not do anything wrong. All they wanted was capital. Instead of the majority to willingly give capital, they wanted to be selfish and greedy by first collecting the 2% of the minority before they give their capital, and then arguing before the court that the reason for collecting the 2% of the minority is because they are going to give capital, and if they don't give capital, the company will liquidate. The court said that he cannot find the connection between the capital and the expropriation, and therefore the alteration was invalid. And then when you go to the case of SIDEBOTTOM and Kershaw, you will see that the expropriation there was because they were competing with the company's business. So that is to the detriment of the company. If you look at the company as an independent entity, you would see that that is to the detriment of the company, and so expropriation will be valid. But then when you look at the other one, that is the case of Dafen Tinplate, there is no way that you giving the power of alteration to the majority, the power of expropriation rather, to the majority can be said to be for the benefit of the company. It is definitely for the benefit of the majority, and therefore when you look at all these cases all together, you will see how the court arrived at this benefit of the company objective test. So now in the part C of my video, I am going to be explaining benefit of the company subjective test. What does that mean? How has the court involved that, and how would we apply that in our cases? We are going to see in that particular video. So make sure that you subscribe to my channel. It is very important because it is just something that keeps me going. The fact that I know that I am doing a good job, enough people to subscribe, people to like, and people to comment. So please make sure you do all these things, and also share my videos so that people in other universities can see what I'm doing. Thank you very much, guys. I love you guys so much. lastly, my name is Olayemi Dear Kolola Daniels.